Welcome to the House of Representatives Committee on Judiciary and Hawaiian Affairs. We are in room 325. It is 2 p.m., Thursday, March 16th. My name is David Tarnas. I'm the chair. We have Vice Chair Greg Takayama and member Kanani Souza. The rest of the members will join us presently. You're testifying today. Thank you very much, because testimonies really help us do our job better, because we hear from you who sometimes know a whole lot more about these things than we do. And so when you do testify, I'd like you to keep your testimony to a couple of minutes, and when we reach that time, I'll ask you to summarize. If you're testifying via Zoom, please don't use any copyrighted images in the background, because then YouTube bounces us off, and then that's no good for anybody. So please help us out by not using any copyright or trademarked images in the back. And if you get disconnected and you're online, don't worry, don't panic, just rejoin us, and we'll try to fit you in when you come back in to provide your testimony. If power goes out and we all have to cancel this, we'll post notice on when we are going to reconvene for the hearing and for testimony. I ask all of everybody here to treat each other with respect and listen to each other and use their best behavior. We're here working on behalf of the people of Hawaii, so let's just keep, it's okay to disagree, but let's not be disagreeable. Let's go ahead and get started on Senate Bill 1538 relating to the judiciary and making appropriations for capital improvement projects for the judiciary. First up, we have support from the judiciary. Sent it in writing. And anyone else wishing to testify on Senate Bill 1538? If not, questions, members? If not, we'll move on to the next. Thank you very much. Just to let you know, Judiciary's testimony was, thanks very much, but for some reason about $500,000 was cut from the Kahumanu Hale, and we'd like it to be reinstated, because we really need to fix up and do some significant work there. Okay, moving on to Senate Bill 151 relating to law enforcement reform. This requires any department or agency employing a law enforcement officer to maintain a publicly available policy that provides a minimum standard on the use of force. It allows use of force policies and training to be considered in legal proceedings involving a law enforcement officer's use of force. It requires a law enforcement officer who observes the use of excessive force by another law enforcement officer to report the use of excessive force. And it requires that law enforcement officers receive training designed to minimize the use of force. First up, we have testimony from the Attorney General in person. Wonderful. Thank you for being here. The floor is yours. Please proceed.
Good afternoon, Chair Tarnas, members of the committee. Amy Murakami for the Department of the Attorney General. We thank you for this opportunity to provide comments on this bill. As to the second added section to this bill, we are making a couple of suggestions. One is to the title, so that it will reflect that the report is of excessive force. That would be on, I'm sorry, page 5, line 5. And also to that section on page 5, line 6 through 14, we're suggesting that the bill be clarified to indicate which officer's information is the controlling information. In other words, is it the officer who's observing or the officer who's using force, that the totality of the information is what their duty is to report. And to that end, we made a couple of suggestions depending on which officer's perspective is being used. As to also to subsection B of the new section, which is on page 5, lines 15 through 19, there was a time of 15 days in which the division had to complete the investigation. We're suggesting that it be substituted with as soon as practical to allow for a full investigation to be conducted and for that investigation to be in compliance with existing rules and regulations that the police departments have. And fourth, the statute it inadvertently requires, but I'll summarize very quickly.
Thank you.
Chair. We're just asking in that to ensure that a person doesn't have to report the wrongdoing of a division head or department head to that division head or department head. So we made some suggestions as to how those issues could be addressed. And lastly, we're suggesting that a definition of excessive force be given in the statute since it is used, and we made a suggestion as to what that definition could be. So thank you very much for the opportunity to provide comments.
Thank you very much. I appreciate your thoroughness of your review and recommended amendments. Next, we have testimony with comments from the Honolulu Police. Manuel Hernandez. Please proceed.
Aloha, Chair Tarnas, Vice Chair Takayama, and committee members. I am Major Manuel Hernandez, in charge of the training division for the Honolulu Police Department. We support the intent of Senate Bill 151. In fact, we currently have policies and procedures in place that either meet or exceed those proposed in the bill. This is including, of course, reasonableness in the use of force, a duty to intervene with regard to unlawful use of force, and use of force training and reporting. However, we do have concerns regarding the language under Section 139, reports of use of force by law enforcement officers in the proposed bill. Our concern is the 15-day timeline contained in the bill in which a division head is to complete an investigation into the reported use of force incident. Administrative investigations into any use of force incident may be complex, and the timeline is not feasible for a thorough, full investigation to be completed. We also have currently in place proper procedures and protocols to properly investigate such instances to ensure appropriate corrective action is administered in the event that inappropriate or unreasonable use of force is utilized. If the concern is a transparency and regular updating of the status of these investigations in question, we recommend that the language of the bill be changed to provide updates to the legislature and the Honolulu Police Commission on the status of these investigations at regular intervals. For example, such as every 60 days until the completion of the investigation. Thank you very much for the consideration of our comments and our concerns, and thank you very much for the opportunity to testify. I will be available for questions.
Thank you, sir. Appreciate that. Next, we have written testimony in opposition from the State of Hawaii Organization of Police Officers. Written testimony in support from the New York University School of Law Policing Project. Testimony in support from Samuel Mitchell, Will Karen, Regina Gregory, and Shannon Rudolph. Is there anyone else wishing to testify in Senate Bill 151? If not, questions, members. Representative Ganadin, please proceed.
Office of the Attorney General, please. Sorry. Good afternoon.
Good afternoon.
Hi. I'm surprised to not see testimony from the newly created Department of Law Enforcement. Is that what they're called? With the
Technically, the Department of Law Enforcement does not officially become, I think, in effect in 2024, if I'm not mistaken.
All right. I'm concerned about policies that this new department is enacting, will enact, or won't enact. I'm raising this concern because about 5 years ago there was an incident in which a disabled man was killed here in the rotunda of the state capitol by a sheriff with the state. There were some issues regarding an investigation, some loss of files, and there was no real clear policy in place. I guess my question is there going to need to be a differentiated policy between that state department and the county police departments?
I apologize, Representative Gannon. It's actually not an area that I can really speak to because, like I said, I'm with the Criminal Justice Division of the Department of Attorney General. I do not represent the Law Enforcement Division. So, I said the Law Enforcement Division is not set to be in place until 2024. So, your concerns regarding whether or not the statute would apply to the State Department of Law Enforcement is, if that's your question, then yes, the statute would, is my understanding. And that the statute as is being proposed takes into account the different levels of within a department.
So
So
we're
I'm,
just-
I'm sorry if I'm misunderstanding.
No, I'm
your
just
question.
trying to understand that we're going to have a blanket policy for this new department and the county police departments, that that this SB 151 ST2 is okay without amendments, covering both the county and the state.
Well, okay, so the department provided its comments regarding items that it thought it was legal or not legal. We're not making any policy call on whether or not this should go forward. We're just providing our comments as to how we think we can improve the legality of the statute.
Thank you.
Thank you very much. Any other questions, members? And my understanding is from the reading of this, this would apply to state and county law enforcement officers.
Yeah.
So but we can discuss this further in decision-making.
Certainly, I'm just surprised to see the lack of testimony from the Office of Law Enforcement.
Noted, noted. Okay, any other questions on Senate Bill 151? If not, let's go on to Senate Bill 372, relating to government services relating to the law. This measure provides that a law enforcement officer has a duty to intervene if the law enforcement officer reasonably believes that another law enforcement officer is using unnecessary or excessive force on an arrestee. It requires the law enforcement officer to report the incident to the fellow law enforcement officer's supervisor and requires relevant departments to submit annual reports to the legislature. First up, we have testimony from the Honolulu Police, Manuel Hernandez.
Aloha again, Chair Tarnas, Vice Chair Takayama, committee members, Major Manuel Hernandez of the Honolulu Police Department Training Division. The HPD supports Senate Bill 372 relating to government services relating to the law. The HPD currently has policies and procedures in place that meet those proposed with the bill, and we continue to support the bill. Appreciate the opportunity to testify this afternoon, and I will be available for any questions. Thank you.
Thank you, sir. Next, we have testimony in opposition from the State of Hawaii Organization of Police Officers. And next, we have testimony in support from ACLU of Hawaii, Mr. Scott Greenwood. Please proceed. Mr. Greenwood, please proceed.
I'm sorry,
There you are.
Mr. Chair. Yes, I thought that we had the representative from SHAPO testifying first. So, Mr. Chair and Mr. Vice Chair, members of the committee, the ACLU strongly supports Senate Bill 372 in its current iteration. We believe that this is a common sense approach that would codify in state law what many of our law enforcement agencies are already doing in the state of Hawaii, as well as current best practices nationwide. A duty to intervene is common sense and consistent with best practices because it imposes, for the first time, an obligation to prevent excessive force from occurring. We think that this iteration could be strengthened by requiring the duty to be imposed when use of excessive force is imminent. We believe that the line is something that professionals in the field are aware of and that it would be easier to apply. As the committee will see, the testimony in favor of this is virtually unanimous, and many cities nationwide are doing this. Both NYPD, Minneapolis after the Floyd incident, San Francisco, Los Angeles, almost every major city in the United States requires a duty to intervene. The Police Executive Research Forum, the Policing Project at NYU, the International Association of Chiefs of Police, and major cities' chiefs of police all have come down in favor of a duty to intervene. It makes it easier for officers, it protects good officers, and it limits the use of force so that it is only used when it is truly necessary. If this is enacted, this will both save careers and will reduce uses of force. We are pleased to partner and to support this bill along with our colleagues from HPD and from other Hawaii police agencies. Thank you.
Thank you very much. And we have testimony and support from the New York University School of Law Policing Project. and testimony and support from numerous individuals, including Samuel Mitchell, Carolyn Azelski, Will Karen, Abir Amirdash, Cards Pintor, Shannon Rudolph, and Naneo Lowe. Is there anyone else here wishing to testify on Senate Bill 372? If not, questions, members? Representative Ganadin, please proceed.
To the Honolulu Police Department.
Yes, sir.
I don't have the data that is right in front of me. I know that the Civil Beat Law Center and other organizations have done some research on this and attempted to publish it. But can you give us an estimation about how many officer-involved shootings happen every year, every few years here in Honolulu, here in, like, on Oahu?
I know that information was shared at a meeting in the past. I want to say it's Police Commission, but I don't want to speak out of turn, sir. I don't have that available directly in front of me right now, but I can get back to you with that information.
All right. Do you think that this bill and other bills to sort of mandate police officer accountability will lower the number of officer-involved shootings, fatalities in the future?
For our departments, in our department's instance, we have a duty to intervene in our use of force policy available, which is visible to the public or for perusal on our public website, honolulupd.org. So we already have in place duty to intervene. I can't give a definitive answer just based on, in my experience of 19 years as a police officer in the Honolulu Police Department. Every situation is different. We have our policies in place to act and react by those rules, regulations, as well as the state of Hawaii laws and federal. So I can't give a definitive answer, but I would like to hope so, that duty to intervene and reform would lower instances. In a perfect world, sir, to be honest, I'd like to see no use of force, but half of the equation are the members of the public that we may or may not encounter. So fortunately, I can't give you a concrete answer on that, sir, but I can get back to you with that data.
Okay, so HPD already has a version of this policy in place.
Correct, sir. Our use of force policy does have a duty to intervene.
Thank you.
Thank you very much. Any other questions, members? Representative Souza.
Can you further elaborate on basically what an objectively reasonable officer is and perhaps how that person is supposed to make decisions?
Well, the reasonable officer standard would be, would another officer in the same situation act within a reasonable manner? For example, if I was in a situation under the exact same situation as the officer in question, would I have reacted in a reasonable manner? Meaning, am I acting within law, policy, and procedure, and training standards, best practices? So kind of like how I was saying, ma'am, every situation is different. However, there is a reasonableness standard. Was the officer acting, or would I be acting under those same circumstances within reason? So of course, by law, in accordance with policy, procedure, and best practices.
Do you think that this law or this particular bill or the contents of this bill would be best implemented in its current capacity as just part of training or just part of department policies and procedures? And do you think it's necessary that it's codified into law?
To be honest, I can't speak for other agencies. I've spent my entire career in law enforcement, and before this as a college student. So I haven't worked for any other law enforcement agency. However, for us, because it's already in policy and it's codified in policy, we abide by it. Also, as the head of the training division, we train not only our recruits but also our incumbents, with the duty to intervene. So, if it's in law, it would apply to other agencies, and I don't want to step on those agencies' toes, ma'am. I apologize for that, but I see the benefit. But for us, it's already in policy, so we abide by it and have been for a while.
Thank you.
Thank you very much. Other questions, members? If not, thank you very much to the testifiers. We'll go on. Next, Senate Bill 210, relating to criminal justice data sharing. Establishes a criminal justice data sharing working group to make recommendations for a statewide criminal justice data repository. First up, we have testimony with comments from the Attorney General. Welcome, sir. The floor is yours. Please proceed.
Thank you. Good afternoon, Chair Tarnas and members of the committee. My name is Phil Higdon, Administrator of the Hawaii Criminal Justice Data Center, Department of the Attorney General. Apologize for our late testimony, but I think everyone has a copy of that
Yes, sir.
now. The Department of the Attorney General supports the intent of this bill. The department understands the importance of working together with the various criminal justice agencies in order to improve the state repository and increase the data shared amongst the agencies. I'd be happy to answer any questions that you may have. Thank you very much, sir.
Thank you. Next, we have testimony with comments from Dr. Aaron Harbinson. Welcome. The floor is yours. Please proceed.
Hello, Chair, Vice Chair, members of the committee. We stand on our written testimony, and I'm available for any questions or clarification that you might need from me. Thank you.
You should introduce yourself. Not everyone knows you.
Sorry. Just very excited to share. Aaron Harbinson, Director of the Criminal Justice Research Institute. Yeah.
Thank you very much. Appreciate that. Next, we have testimony and support from the Department of Public Safety. And next, testimony with comments from the Legislative Reference Bureau. And testimony and support from the Hawaii Correctional System Oversight Commission. Testimony and support from the Crime Victim Compensation Commission. Welcome. The floor is yours. Please proceed.
Good afternoon, Chair, Vice Chair, members. My name is Pam Ferguson-Bray, and I'm the Executive Director of the Crime Victim Compensation Commission. We support the bill with a proposed amendment to include the Crime Victim Compensation Commission on the working group. In addition to running a crime victim compensation program, we also run a restitution recovery project. This project was developed in 2012 when the Justice Reinvestment Initiative was implemented in order to create a more data-driven approach to restitution collection in Hawaii. And so we have an article, actually we've done an article with the Council of State Governments about our efforts and success in making a data-driven project which involves inmates and parolees in the system. We collect restitution. As part of the project, we have an agreement, an MOU with the Criminal Justice Data Center to share information about restitution across the system. What we've noticed over the last couple of years is data is falling away, that while we have the same inquiries, that we are no longer able to get the quantity and quality of data for this project, which, as I said, really drives policy-making decisions and efforts to maximize the collection of restitution in Hawaii. So I think it's important for that effort to be a member of the panel so that we can ensure that we have access and policymakers have access to that information. Thank you very much.
Thank you very much. Next, we have testimony and support from the Department of the Prosecuting Attorney, City and County of Honolulu. Welcome. The floor is yours. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee, Deputy Prosecutor Tricia Nakamatsu, appearing on behalf of the Honolulu Prosecuting Attorney's Department. We are in strong support of this bill. We do feel that there is a need for improved system-based data sharing, essentially, that would allow, particularly, one of the biggest interests is having real-time data sharing, and real-time not in the second-to-second perhaps, maybe there's a few minutes delay, something like that, but having a way to get information transferred between agencies in less than a day, perhaps less than an hour, something that could actually be useful to officers in the field, useful to our deputies who are making decisions regarding cases moment to moment with regards to screening or even in court perhaps, but this is a working group. It would be a start, and it's something that I think we're open to have. Again, it's not our bill. I'm sorry, I should point out first that it's not our bill. We are in strong support, but we would welcome, I believe, CVCC, AGs, any all stakeholders being part of this. Open for questions, if any.
Thank you very much. Next, we have testimony and support from City and County of Honolulu, and testimony with comments from the Civil Beat Law Center for the Public Interest, and testimony and support from Samuel Mitchell. Is there anyone else here wishing to testify in Senate Bill 210? If not, questions, members. Prosecuting Attorney? We heard HB 100.
Yeah.
Which is from City and County of Honolulu.
Correct.
And this is Senate Bill 210, which we've got, I thought was also from the City and County of Honolulu. It's just not from your office, is that it?
Neither of them is from our office.
Oh, okay. I guess it's mislabeled.
Oh,
It just says
Does it
it's,
say it's
it
part
it
of our
just says
package?
it's from a package of the City and County of Honolulu.
oh, not from the prosecuting attorney's office.
So it's not from your office, but it's from the City and County of Honolulu's
I believe
package.
so, yes.
Got it, okay, now I understand. Okay, thank you very much, appreciate that. Any other questions, members? Representative Ganadin.
Office of the Attorney General.
Yes, sir.
Are these meetings going to be subject to the Sunshine Law here in the state of Hawaii?
It doesn't appear so at this time, no.
How do you feel about the request from the Civil Beach Center for Public Interest requesting public access to these meetings?
Well, a lot of the information that will be shared is only can be shared amongst criminal justice agencies. We're dealing with arrest data. Conviction information is public, but a lot of the information that is being put into the system now and will be in the future is arrest information, which is not access to the public. Only criminal justice agencies, judiciary, probation, and so forth.
How do you feel about a member of the working group who represents a community organization, one of the many nonprofit organizations, advocacy groups that advocate for those who find themselves entangled with the justice system?
Well, as I go back, a lot of the information that we would be speaking about or sharing is information that is not for public dissemination. So I don't have a personal thought on that. I haven't talked to the Attorney General about that either. I apologize. I can speak to her regarding that matter.
I understand. I think I share a concern about continuing transparency in policies and data sharing.
Correct.
And using that data so that, your county and state governments can come up with better policies. So, data can shift around. So supposing that maybe you could get an idea for the next hearing.
Sure. I can tell you this. If there's data that if the public or another agency that doesn't have authorization to receive certain information, arrest data, we give it an aggregate. So there's no identifying name, anything that would identify an individual. So that information we can share, but we have to break it down and provide aggregate information. I don't know if that helps answer your question or not, sir.
Well, it sort of does. It sort of doesn't. Legislators are
Sure.
Always concerned about rising and falling rates of crime, trends, those kinds of things, and ways to speak to our own constituents.
Right.
So would it be helpful, considering that those are the concerns of legislatures, to have somebody from the public or a legislator involved in these policy conversations?
I mean, any input I think would be beneficial. As I look at this bill and what is being proposed, it is providing real-time, more efficient data. The data center, I look at it as the library. We don't write the books. The information is only as good as what we get from the prosecutors, judiciaries, the police departments, and it always starts with an arrest, and then it's built upon that. So certain information we can share, some certain information we're unable to share by state statute. So I'm not saying that the working group would try to hold information back. I mean, transparency is good, but there are restrictions on what can be shared with the public and other groups.
I understand.
Yes.
One more, Chair.
Okay.
Okay. I don't see an appropriation here. Are these, you can't speak for other agencies, is obviously the Attorney General capable of doing this data sharing and this work and this working group with the staff that you have?
Well, if you're talking about a repository, that's part of the bill. Right now, that repository is, we created that with federal funds, and this was well before my time, very limited state funds. So as a working group, I don't think there would be the need for funds because it's a group, the members coming together and speaking and hashing out our concerns and trying to work towards a common goal. But if you're talking about creating a new repository, I would only guess, and I'm only guessing, it would be millions of dollars.
Thank you.
Thank you very much. Yeah, and just to draw attention of the members, that part of the bill authorizes the Legislative Reference Bureau to provide proposed legislation drafting assistance to the working group upon request of the working group's chairperson by no later than October 1st of each year. And the LRB submitted testimony saying that they believe that the services requested under the measure are manageable, so that they would be able to provide that assistance. Okay. Any other questions, members? If not, let's go on to the next measure. Thank you for the testifiers. Senate Bill 926 SD1 relating to pedestrians. It authorizes pedestrians to cross a street when a reasonably careful pedestrian determines that there is no immediate danger from a collision with a vehicle. First up, we have testimony and support from the Office of the Public Defender. Welcome, Mr. Hayakawa. The floor is yours. Please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, members of the committee. My name is Lee Hayakawa, and I am the Chief Deputy of the Office of the Public Defender. The Office of the Public Defender strongly supports SB 926 SD1. It places good judgment and common sense back into the hands of the everyday pedestrian, whereas pedestrians can once again assess the traffic situation on their own and discern on their own whether it is safe to cross. The testimony that we wrote addresses mostly, and again, we are sensitive to the ways in which jaywalking citations have been abused or potentially abused by law enforcement. And so SB 926 SD1 will put an end to that. Thank you for this opportunity.
Thank you very much. Next, we have testimony in opposition from the State Department of Transportation. In person. Oh, happy day. Go ahead.
Good afternoon, Chair, Vice Chair, committee members. Melissa Miranda Johnson for the Department of Transportation, and we will stand on our testimony in opposition.
Could you just briefly summarize, just so people know if they're watching?
We're just concerned that, you know, the expectation of users of roadways, which of course would be vehicles especially, would not be aware of pedestrians crossing in unmarked crosswalks or at any junctures, and so of course that could make the roadways a little bit more dangerous, and we're a little bit more concerned for our elderly and keiki, of course.
Thank you very much.
Thank you.
Okay, and we have testimony and support from the State Council on Developmental Disabilities. Welcome. Please introduce yourself. The floor is yours. Please proceed.
Aloha, Chair, Vice Chair, members of the committee. My name is Annabelle Doherty, the intern here on behalf of the council. We'd like to stand on our testimony and support. Thank you.
Thank you very much. Next, we have testimony in opposition from the Honolulu Police. Stason Tanaka, please proceed.
Aloha, Chair Tarnas, Vice Chair Takayama, and members of the committee. Major Stason Tanaka from HPD's Traffic Division. We're in opposition of it because we believe that motorists may not be expecting pedestrians to be crossing at areas not designated by a crosswalk. I'm going to give you some statistics, and this is from 2020, 21, and 22 regarding pedestrian fatalities. So in 2020, we had 16 pedestrian fatalities. Of those, 10 of which were not in a marked crosswalk. For 21, 17 total, 12 of which were not in a marked crosswalk. And for 22, 15 total, of which 12 were not in a marked crosswalk. I'm also going to talk about pedestrian critical collisions. In 2020, we had 8 total, 6 of which were not in a marked crosswalk. In 21, 7 total, of which 6 were not in a marked crosswalk. And in 2022, a total of 3, 2 of which were not in a marked crosswalk. So the other speaker from the DOT mentioned about it might be challenging, especially for children and elderly, and I agree with that. And I'm in agreement because sometimes children and especially elderly, they might not be able to judge speed. So especially we see that in elderly. It's a long street, and in their mind they can make it. in the time allotted, and they're not able to judge the speeds of the cars approaching, and sometimes that can lead to collisions. So I just think that just the unexpectedness of pedestrians crossing where vehicles are not expecting these people to be might be problematic and lead to more collisions. Thank you.
Thank you very much. Next, we have testimony and support from Samuel Mitchell, Makiki Neighborhood Board. Testimony with comments from Grassroot Institute of Hawaii. Testimony and support from the Hawaii Public Health Institute. Testimony and support from numerous individuals. Well, testimony and support from C.J. Johnson. Please proceed.
Hey, good afternoon, everyone. Good afternoon, Chair Tarnas Committee. My name's C.J. Johnson. I'm ready today to strongly support SB 926 SD1. I submit this testimony as a survivor of traffic violence, a transportation safety advocate, a member of the National Voices for Decriminalizing Mobility Work Group, a lead organizer for the Hawaii Safe Routes Coalition, a co-founder of the Hawaii Transportation Equity Working Group, and a longtime advocate for mobility justice and health equity. In short, there is little evidence of a relationship between jaywalking enforcement and safe mobility for people walking and rolling. I have been asking for evidence like that for years, so if anybody has any, I would love to see it. The safest cities and countries for people walking, rolling, and biking have things in common, but it is not exotic technology or police states or perfectly trained, perfectly compliant citizens. The safest cities favor resilience and inclusion and supportive environments for all users over compliance and blame. They design and build streets and neighborhoods that curb motor vehicle speed. They offer robust transit access. They promote pedestrian safety in numbers. They reduce exposure time and distance, and they prioritize the mobility and inclusion of older adults and disabled people in systems and account for the inevitability of human error. The United States is unique in its victim blaming, its hostility and indifference to pedestrian safety, its over-reliance on policing as an alternative to systems, policies, and environments that prioritize the mobility and dignity of people walking and rolling. In my written testimony, I share several examples of significant and mounting evidence that prioritizing enforcement disproportionately harms historically marginalized communities, and I detail the increasing momentum among leading transportation safety advocacy orgs like America Walks, the Safe Routes National Partnership, the League of American Bicycles, to refocus the conversation away from policing and enforcement and victim blaming and towards systemic, equitable safety solutions. Also say that several states and cities have already adopted freedom to walk policies that are very similar to this, and many others are considering it. I'd also say to the suggestion that seniors and children are more likely to use this bad judgment, does that mean that the solution is to give them tickets and to give them, to increase enforcement against them? I don't think we should be ticketing kids and old people personally. Thank you for the opportunity to testify on this important issue.
Thank you very much for your testimony. We have testimony and support from numerous individuals: Andrew Crossland, Christy McPherson, Carolyn Azelski, Jennifer Chiwa, Emily Warren, and Kiana Otsuka. I think we also have testimony from Kaili Swan. Please proceed.
Vice Chair, hello, committee, Vice Chair and committee members. My name is Kaili Swan. I'm in strong support of, which bill was it?
Senate Bill
SB
926.
Thank you, 926. SD1 relating to pedestrians. I'm a strong advocate of this bill because I want more speed humps in my area, because one of my area has speed humps because too many people are speeding. There's so many collisions in my areas, and I almost got struck by a car while crossing the street. If you can add more speed humps and lower the speed limits, that would be grateful, because my areas, a lot of people are speeding recklessly in this area. If you have any questions, please let me know, and please pass this bill.
Thank you very much.
Thank you so much.
Is there anyone else here wishing to testify in Senate Bill 926? If not, questions, members? Seeing none, thank you very much to the testifiers. We'll move on to the next measure, Senate Bill 933, relating to temporary restraining orders. This measure allows petitioners to attend temporary restraining orders hearings, often called TRO. Temporary restraining orders is TRO. So it allows petitioners to attend TRO hearings remotely when domestic abuse is alleged. For Senate Bill 933, first up, we have testimony with comments from the judiciary. Welcome, sir. The floor is yours. Please proceed.
Thank you. Good afternoon, Chair Tarnas, Vice Chair Takayama, honorable members of the committee. I'm Andrew Park, and I'm a family court judge in Kapolei. We offer comment. We definitely understand that petitioners may be intimidated by the physical presence of the respondent in the courtroom. We're asking that you consider our proposed amendment, which would mandate the court consider certain factors. I noted testimony submitted by Restraining Orders Without Borders, and I can't speak for every judge in the state, but I know that, for me, if we're accepting out-of-state restraining orders, then that would be a authorization to allow that petitioner to appear remotely. We just would ask that the court, that the committee consider allowing the court to retain some discretion to prevent potential misuse by, for example, perpetrators of domestic violence or other situations that might not be accounted for with a mandatory remote appearance. I'll stand by for any questions. Thank you very much for the chance to testify.
Thank you very much, Judge. Next, we have testimony and support from Angelina Mercado, Hawaii State Coalition Against Domestic Violence. The floor is yours. Please proceed.
Good afternoon, Chair, Vice Chair, committee members. I'm Angelina Mercado, the Executive Director of the Hawaii State Coalition Against Domestic Violence, and we are in strong support of this measure. We recognize very much the issue that survivors face when they are attending their order to show cause hearings. It's actually in the TRO process that can be an ex parte, so the respondent is not there, but it's in the order to show cause hearing where both parties are there. And we've heard from survivors who have had the experience of being intimidated by the respondent. We've actually had the experience of survivors being intimidated in the parking lot of the family court in Kapolei, where let's say the order came out against the respondent, and then you have the petitioner of the respondent's entire family setting off all of their car alarms in the parking lot of Kapolei. And if you've been in that parking lot, you know that it's open air and you can come outside. So, we definitely take into consideration the fact that it's a safety measure for survivors of domestic violence. This is actually already happening in the Maui circuit, where Women Helping Women does 90% of the protective orders, and most of their survivors do it from their office. And we want that to be consistent across all circuits. It's also about economic justice and access to the court. Too many survivors, and our data has shown it, too many survivors who have less economic advantage in our community are most often the ones that are sensitive to abuse. So you have people who are working multiple part-time jobs who are not able to come to court all the time. We don't have enough childcare for anybody. And I'd like to add that our Chief Justice recommended remote testimony. Thank you.
Thank you very much. Next, we have testimony in support from the Domestic Violence Action Center, testimony in support from Restraining Orders Without Borders, and testimony in support from numerous individuals: Cheryl B., Samuel Mitchell, Alexandra Chow, Carolyn Lee, Deanna Espinas, Cheryl Harris, Alyssa Rabinowitz, Amy Chung, and Dara Carlin. Is there anyone else here wishing to testify on Senate Bill 933? If not, questions, members? Representative Ganadin, please proceed.
To the judiciary. To the Honorable Judge Park.
Hi, Representative Ganadin, thank you.
Hi. A little bit taken out. I didn't realize you'd been appointed to the bench. Congratulations. So.
It's hard to believe.
Yeah, I don't want to believe it.
I believe.
Yeah, we're the same age. I feel old. It's been years since I was a staff attorney at the Domestic Violence Action Center, and I get the sense that technology is moving quicker than our laws are, especially when it has to do with remote testimony, the way trials are being conducted, a variety of other things. It sounds like the Second Circuit is already moving forward with Chapter 586 hearings. That's the portion of the Hawaii revised statutes that is in regards to temporary restraining orders turning into full protective orders during an order to show cause hearing. Do we need to amend the Hawaii Rules of Evidence to allow for this new way of testifying before the courts? Because, I mean, the way, we were trained in law school, you lay the foundation for evidence, you present it, it's presented to the other side. There's actually quite formal ways to show evidence to a court. So, so how do we change evidence to catch up?
Thank you for the question, Representative Ganada. I think we had a similar discussion on the House version of this bill. There's a Hawaii Rules of Evidence Committee, which I'm not on and I'm not asking to be on. But I think your point is a good point, because these Chapter 586 hearings, a lot of times the first court date that's the trial, right? And I think part of the consideration in our testimony is that there's the chance that a person appearing remotely might not have the same ability to participate fully in the trial. So I guess my answer is I don't know what can be done about the rules of evidence or about how those are applied to these hearings. I suspect that we may soon be finding out how that's going to work with these hearings. Yeah, that's as good as I can do right now. Apart from the technical issues, I think what was described by Ms. Mercado on Maui, it sounds like a pretty good setup where the petitioners are at kind of a set place, right? Yeah. Where they can get technical assistance. It might be different if a petitioner is logging on from their home. I tried to participate in a committee meeting the other day from my office, and my camera froze for 30 seconds, and I had to unplug it and reboot the USB or whatever. And that can be frustrating, and that can add stress to the process. So, our testimony is comment only, and we're offering up proposed language and to even make a form and to be required to consider certain things, but we leave it up to you.
All right. Maybe could I pose it to Ms. Mercado, Kim?
Sure.
Yeah. These Chapter 586 hearings, this was my introduction to the profession. I clerked for Rick Bisson, who's now the mayor of Maui, when he had to do the TRO calendar. How are petitioners introducing evidence to the court?
That's a good question. I know that at least on Maui County, when it's been done, they work a lot with women, helping women, so they have faxed over their petition, and they probably, I know the petition is faxed over, but I'm not quite sure how that evidence is introduced by the court. I know if they are deaf, I don't know the answer to that.
Okay.
Yep.
So it's usually, I'm guessing they probably fax over the petition or email over the petition, as well as the prospective evidence that they hope to use during the trial. And then the court most likely makes a ruling on the admissibility of that evidence and takes that into consideration when deciding the case?
Correct. That's as far as I know, and I know the petition itself has a very long narrative part to it, and a lot of that descriptive cannot be added through fax or sent through fax. I know that Maui does fax for a fact.
That's good.
Thank you. I think I...
Wonton.
Yeah.
Touche.
Yeah. Thank you very much.
Thank you.
Thank you. Thank you very much. Any other questions, members? All right. Thank you for the testifiers. And let's move on to the next measure relating to expungement. Senate Bill 1079 requires courts to, upon written request, expunge records of convictions for operating a vehicle after consuming a measurable amount of alcohol while under the age of 21 years, and certain property offenses if the sentencing occurred prior to 1998. First up, Senate Bill 1079, we have testimony with comments from the judiciary. And next, we have testimony with support from the Office of the Public Defender. Welcome, Mr. Hayakawa. The floor is yours. Please proceed.
Thank you. Good afternoon, Chair Tarnas, Vice Chair Takayama. My name is Lee Hayakawa. I'm the Chief Deputy of the Office of the Public Defender. The Office of the Public Defender strongly supports SB 1079 SD1. Everybody loves a comeback story, whether it's Brendan Fraser winning an Oscar after overcoming a multitude of personal issues, and including harassment, or Bethany Hamilton, surviving a horrific shark attack and continuing to serve competitively. No, admittedly, the clients that we have that may benefit from SB 1079, much of their misfortune is self-inflicted. But even that being said, they still show resilience, they show determination. I think it shows character to come back from having committed a criminal violation and to sort of turn it around. And it's these individuals that I'd like to see them benefit in this way, to be able to say they have a clean record, especially after a period of, sort of a waiting period of 25 years. And so the Office of the Public Defender does support SB 1079 SD1. Thank you for this opportunity.
Thank you very much. Is there anyone else here wishing to testify on Senate Bill 1079? If not, questions, members? Representative Gannon, please proceed.
Sorry, Mr. Hayakawa. Sorry, making you get back up. Why in the statute are we saying 1998? Did we just pluck that out of thin air?
You know, I've tried to figure that out. I mean, Office of the Public Defender didn't author this bill, and so I am kind of curious. I'm guessing just because, I mean, a conviction that's 25 years old may actually be safe to expunge at this point in time.
Would it make more sense if we just said 25 years after the conviction?
I suppose. We're hoping actually that this will go well and that we might expand it to other charges. In different states, they're toying with expungement for everything from, you know, any case or any charge could be expunged, and then there's also the waiting period as well they're toying with. So we're hoping that we can move this forward once we have this in place.
That said, do you think that this, I mean, 1998 wasn't a bad year, but it's just also a kind of random year to be throwing into a statute?
Right, I was thinking we have attorneys in our office that weren't born.
Goodness gracious. Yeah.
So,
okay, all right. Just food for thought. I suppose maybe a prospective amendment, either in this or in future measures, to not choose a specific date in the 90s. Thank you.
Thank you.
Thank you very much. Other questions, members? If not, thanks very much to the testifiers. Let's go ahead on the next measure. Senate Bill 1267, relating to protective orders. This measure allows non-residents to apply for a temporary restraining order or order for protection in cases of domestic abuse. Allows non-residents to apply for a temporary restraining order and an injunction from further harassment. On Senate Bill 1267, first up we have testimony and comments. Testimony with comments from the judiciary. Floor is yours, Judge. Welcome.
Good afternoon again, Chair Tarnas, Vice Chair Takayama, honorable members of the committee. We take no position. There was a lot of powerful testimony submitted the first go around for this, as well as the companion bill, which I appreciated reading. We're thankful for the amendments made to this particular bill by the JDC and SD1. Because it is going to require operational changes for the judiciary to include accommodating the out-of-state filers to figure out how we can help them do that or how they can actually do that. We're asking for an effective date of September 1st so that we can implement all those, probably create a new form, make sure that it's ADA compliant before it goes live on the website. And thank you very much for the opportunity to testify. I'll stick around for any questions.
Thank you very much. Next we have testimony and support from Samuel Mitchell, Makiki Neighborhood Board. Next we have testimony and support from Angelina Mercado, Hawaii State Coalition Against Domestic Violence.
Aloha Chair, Vice Chair, committee members. I'm Angie Mercado, the Executive Director of the Hawaii State Coalition Against Domestic Violence, and we respectfully submit testimony in strong support of this measure. This was actually at the request of a survivor who had a very unique, well, not so unique experience here in Hawaii. We know that there are many other states who already allow these non-residents in certain circumstances to petition for an order of protection, and we also support the judiciary's recommendation to have the effective date be September 1st. We hope to be working with them to also train our local advocates and how to use these new forms, and available for any questions you may have. Thank you.
Thank you very much. Next we have testimony and support from Naziha Khan from Restraining Orders Without Borders. Please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and members of the committee. Thank you for the opportunity to testify again and for your support for this bill's companion, which is HB 752. My name is Nazia Khan. I'm the sexual assault survivor which prompted this bill, and I'm the founder of Restraining Orders Without Borders. This bill safeguards Hawaii's 300,000 survivors and 10 million annual visitors It would give Hawaii the opportunity to join 14 states with the most comprehensive restraining order access laws and the 25+ states which already implement variations of this bill. Just briefly on impact, since the last hearing, I've heard from sexual assault survivors, social workers, and even strangers who are gaining a voice and protection through this bill. I was especially touched by a former classmate who reached out to me after many years and is currently sheltering his 2 cousins on the mainland. Like me, they were born and raised in Hawaii, they were sexually assaulted, and they fled to the mainland for their safety. Our current laws would not allow them to request a restraining order in Hawaii. And without a restraining order, Hawaii becomes a battleground for survivors versus being the safe haven we once knew it to be. It can take a lifetime for a survivor to feel safe in their body again, but this bill would give them the right to at least feel safe in their home. I strongly encourage the committee's passage of SB 1267 and support the amendments of the Hawaii Judiciary. Thank you for giving our plea for protection a voice and giving me the chance to testify. I'll be available for questions.
Thank you very much, and thank you for your advocacy. Next, we have testimony and support from numerous individuals: Renuma Khan, Sarah Pearson, Kelly Oosterman, Zoha, Caitlin Ryan, and Dara Carlin. Is there anyone else wishing to testify in Senate Bill 1267? If not, questions, members? I don't have a question. I just want to, again, express my gratitude to Ms. Khan for educating us and initiating the whole effort that has produced this measure. I think it's going to help a lot of people. So my deepest mahalo. If there's no further questions, members, thank you to the testifiers, and let's move on to the next measure. Senate Bill 1277, making appropriations for claims against the state, its officers, or its employees. First up, we have testimony from the Attorney General. Welcome. The floor is yours. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. Karen Inagaki, Deputy Attorney General. This is the appropriations bill for claims against the state and its employees. The current bill contains 15 claims, and those claims are described in our testimony attached as Attachment A. And since the bill was last amended, there have been 9 new claims, and those claims are described in our Attachment B. And so with the, including the new claims, the appropriation request is for 24 claims for a total of $7,571,395.42. And we would ask that the bill be passed with amendments to add the new claims, and I will be happy to answer any questions.
Thank you very much. Next, we have testimony and support from the Department of Education, testimony and support from the Department of Transportation, and testimony and support from Dara Carlin. Is there anyone else wishing to testify on 1277, Senate Bill 1277? If not, questions, members? I do have one question for the Attorney General. I'm just curious, is there any effort that you're aware of that tries to educate agencies about risk management and trying to prevent things that are creating these situations where we have to have settlements like this? Is there?
Yes, actually, by statute, we are required to contact the departments to advise them, to give them legal advice as to how they can avoid similar incidents from occurring again. They are required to respond and tell us what they're doing to meet our recommendations.
And after that first response, is there any follow-up to make sure that they're implementing whatever they say that they learned?
There is no formal process in place, but we are certainly available at any time for them to ask us for advice, and we do provide that.
They would have to initiate it?
That's correct.
I see. Okay, I'm just trying to understand this because it's quite remarkable and stunning that since the last action on this measure, there's been all these additional, since the bill was last amended, 9 new claims were resolved, totaling $4.2 million. I mean, it's just, I appreciate that there is follow-up and you do try to educate them, but I just have to learn more about it to see if we can make any improvements in the system. If you have any suggestions, please contact me so maybe we can work on this going forward.
certainly.
Thank you very much.
Okay, thank you.
Any other questions, members? Yes, Representative Ganadin.
To the Attorney General. This is hard to discuss, but in reviewing the attachment A of your testimony, many of the cases involving the state of Hawaii have to do with sexual assault and claims by parties going back years. I think we have other bills moving through the legislature which would extend the statute of limitations for parties in making claims against defendants, including the state, for these sorts of cases. Do you think we should increase the amount, considering that there might be more plaintiffs coming forward?
I'm sorry, what was your question?
I mean, is this enough money?
Well, what this bill is that we ask for appropriations for the claims that we are settling or have been required to pay by judgment. So it wouldn't be for future claims or potential claims. It's just the actual claims that have been resolved.
Okay, thank you.
Thank you very much. Any other questions, members? If not, thank you very much to the testifiers. Let's move on to the next measure. Senate Bill 297, relating to grants and aid. It requires organizations to obtain legislative approval prior to the disposition of land that was acquired using state grants, but only if the land was acquired after the enactment of this act. First up, we have testimony in support from the Hawaii Office of Community Services. Is there anyone else here wishing to testify on this measure? If not, we'll go on, since we can't question the testifier who did not appear. Moving on to Senate Bill 494, relating to vacant and abandoned residential property. This measure requires counties to establish expedited procedures to approve demolition permits for vacant and abandoned residential properties. It allows the Department of Taxation to satisfy certain tax liens through the non-judicial foreclosure of vacant and abandoned residential properties at any time after establishing vacancy and abandonment, and makes an appropriation. First up, we have comments from the Department of Taxation. Thank you for your patience. Please proceed.
Chair, Vice Chair, members, my name is Brian Davidson. I am with the Department of Taxation. We had provided comments on this bill, and I am available for any questions that you may have.
Could you please summarize the testimony for those who haven't had a chance to read it and are listening, your audience?
Essentially, our comments are more administrative, if anything. It just provides that a permit must be issued within 21 days upon application by an applicant, and that the purpose for this legislation is to demolish vacant and abandoned property. It's not intended to reconstruct, renovate, rebuild existing property. It's for the full demolition. If someone were to come in and try and ask for permission to rebuild on that vacant lot within 365 days of the actual demolition, that it would be denied. So the push here is really to demolish those eyesores and those vacant properties that are troublesome spots for counties.
Thank you. And your testimony does say that the department is able to implement this measure with an appropriate effective date.
That is correct.
Accurate? Okay.
Yes.
Thank you very much. Appreciate
Absolutely.
your summary of your testimony.
Appreciate it.
Next, we have testimony with comments from the Department of Planning and Permitting in person. Thank you, sir, for being here. The floor is yours. Please proceed.
Good afternoon, Chair, Vice Chair, committee members. I'm Curtis Lum, Department of Planning and Permitting. I'm glad you got our testimony because we submitted it kind of late. Also apologize for our director, Puna. She was in a meeting with the mayor when I left. We support the general intent of this bill. We do have a request for maybe a delayed effective date because we may have to adopt administrative rules for this. And also the amended version reference where if there's a building permit application for reconstruction or rehabilitation or new construction, we would have to deny it within, if it's submitted within 365 days of the issuance of a demolition permit. But a lot of times applicants will put in for a demolition permit while they're developing plans for the property. So they would submit a building permit application while the demolition is being done or something. So if we have to wait a year before we even accept that application, that'll just delay the construction for the new owner or the owner a year. And we're already criticized for being slow in issuing permits. So if we have to wait a year before we even accept an application, that might cause a very big delay for the property owner. So that's we just ask that section be looked at and possibly deleted. And I'm available for questions. Thank you.
Thank you very much. Thank you very much, Mr. Lum. Next, we have testimony and support from Calvin Say, Honolulu City Council. We have testimony and support from Tommy Waters, Honolulu City Council. And we have testimony and support from Samuel Mitchell, Makiki Neighborhood Board. Testimony with comments from the Tax Foundation of Hawaii. Please proceed.
Yes, good morning. Good afternoon, Chair Tarnas, members of the committee. This is Jay McMillan on behalf of the Tax Foundation of Hawaii. We have submitted some comments on the measure. We're going to stand on our written comment. Primarily, we have mentioned that DOTAX already has the power to proceed with the non-judicial foreclosures. And additionally, under the bill to proceed with the non-judicial disclosure, DOTAX must establish that the property is a vacant and abandoned. So if they go ahead and do that by inspecting the property for 2 separate occasions, separate days, 7 days apart, different times of day, the property could still be deemed not abandoned if established so by mail delivery or utility usage. So it seems it would have to be one or the other in those 2 cases. So thank you very much.
Thank you very much. And we have testimony and support from Ellen Godby Carson. Is there anyone else here wishing to testify on Senate Bill 494? If not, questions, members. Mr. Lum, quick question for you, sir. The bill says that a parcel owner may appeal a denial of a permit application pursuant to this section, which is the 365-day delay in receiving and being able to submit a permit application. A parcel owner may appeal a denial of a permit application pursuant to this section through the appeals process established by the planning department in the county within which the parcel is located. So you do have an appeal process?
Yes, it's through our Building Board of Appeals.
Okay.
Which meets very infrequently. So they could have filed an appeal, it would have to get scheduled for a hearing, then it would have to get scheduled. I mean, just to get on the schedule would take a while.
What does that mean, like a month, 2 months, 3 months, 6 months?
This board, it's not like the Planning Commission or Zoning Board of Appeals, which meets on a very regular basis. The BBA, it's when they can get quorum. So, yeah, it would delay.
I understand it would delay it. I'm just curious how long an appeals process would.
I'm not sure. But
you don't know? Okay.
It could take a while.
Okay.
Yeah.
Thank you. Any other questions, members? If not, thank you to the testifiers. Let's move on. Senate Bill 221, making an appropriation to the Department of Prosecuting Attorney, the City County of Honolulu, as a grant and aid for the Victim Witness Assistance Program. First up, we have testimony and support from the Department of the Prosecuting Attorney. Welcome.
Good afternoon again, Chair, Vice Chair, members of the committee, Deputy Prosecutor Tricia Nakamatsu, appearing on behalf of the Honolulu Prosecuting Attorney's Department. We thank you very much for hearing the bill, Chair. We're in strong support. It is part of our legislative package. And understanding that the committee has already heard the companion bill previously, I won't belabor the point, but victim witness advocates are a very crucial part of our department. We want to make sure that we can maintain the current level of service because these are highly specialized counselors, most often with a social work background, who are able to bridge between the often confusing and frustrating criminal justice process that these victims suddenly find themselves involved in, typically through no choice of their own, and the deputy prosecutors who are trying to prosecute the cases. Available for questions. I'm sorry, the amount that we're asking for is $736,785. Thank you.
Thank you very much. Next, we have testimony and support from the Attorney General.
Good afternoon, Chair Tarnas, Vice Chair, Committee. My name is Julie Ibato. I'm the Crime Prevention Justice Assistance Administrator with the Department of the Attorney General. We submitted testimony in support of this measure. The Department of the Prosecuting Attorney, City and County of Honolulu, is one of the 4 recipients of the State Victim Witness VW Assistance Funds. The program funding has not been adjusted for inflation and actual costs for program staff since 1995. For the 28-year period covering fiscal years 1994, 1995 to 2022, 2023, the State Victim Witness funding has steadily declined. For fiscal year 1994, 1995, the State Victim Witness allocation was a little over $1 million, and the fiscal year 2022, 2023 allocation is currently $401,000. The funding supports the Victim Witness Assistance Program as established by Section 28-111 Hawaii Revised Statute, and really increases the public-private efforts to assist witnesses and victims of crimes and to minimize the cost of victimization. The Victim Witness Program administered by the Department of the Attorney General is to provide information, assistance, and support services to victims of and witnesses to crimes committed in the state. This bill benefits the Department of the Attorney General by providing prosecuting attorney with additional funding to assist victims and witnesses of crimes in the City and County of Honolulu. We respectfully ask that the committee pass this bill. If you have any questions, I'm available.
Thank you very much. And we have testimony and support from Derek Carlin. Is there anyone else here wishing to testify in Senate Bill 221? If not, questions, members? Vice Chair? Nope. Okay, thank you. To the testifiers, we'll move on. Senate Bill 222, making an appropriation to the Department of Prosecuting Attorney in the City County of Honolulu as a grant and aid for the Career Criminal Prosecution Unit. First up, we have testimony and support from the Department of Prosecuting Attorney, City County of Honolulu.
And thank you again, Chair, Vice Chair, members of the committee, Deputy Prosecutor Tricia Nakamatsu, on behalf of the Honolulu Prosecuting Attorney's Department. Chair, we thank you for hearing the bill. We are in strong support. This is part of our legislative package. And again, this is very crucial funding for our department. It is to retain warm bodies in our Career Criminal Prosecution Unit. And as the committee knows already, I'll just highlight that these are very experienced deputies who can get the best possible outcomes for these types of cases. They're typically some of our most experienced and most skilled deputies because they are dealing with a specialized group of offenders who essentially make up, they're a small group of offenders who make up a large percentage of the crime that is committed in Honolulu. So we want to make sure that this unit continues to handle its current caseload. There have been times in past administrations when their caseload or actually the number of people had to be cut due to lack of funding. Available for questions, if any.
Thank you. And your request is $708,806.
Correct. Thank you. Thank you, Chair.
Thank you very much. Okay, next we have testimony and support from the Attorney General.
Good afternoon, Chair Tarnas, Vice Chair Julie Bato, Department of the Attorney General, Crime Prevention Justice Assistance Division Administrator. The Department of the Attorney General supports this measure. The Department of the Prosecuting Attorney, City and County of Honolulu, is one of the 4 recipients of the state CCP funds. The state CCP funding is used to support the salaries and fringe benefits of the program staff. However, the program funding has not been adjusted for inflation and the actual costs for program staff since 1995. Over time, less staffing is supported with state CCP funds. For the 20-year period covering fiscal years 1994-1995 to 2022 to 2023, state CCP funding has steadily declined and has not seen any significant increase. For fiscal year 1994-1995, the state CCP allocation was about $2.6 million, and the fiscal year 2022-2023, the allocation is $1.2 million. The funding would help fulfill the requirement of Chapter 845 Career Criminals Hawaii Revised Statutes that established the statewide career criminal prosecution program, whose purpose shall be the investigation and prosecution of those persons identified as habitual or career criminals. The CCP program is administered by the State Department of the Attorney General and is conceptually based on the establishment of a highly skilled prosecutorial unit within each of the county prosecuting attorney's office. The criteria established by Chapter 845 HRS serves to identify the career criminals. The bill benefits the Department of the Attorney General by providing the prosecuting attorney with additional funding to pursue habitual and career criminals in the city and county of Honolulu. We respectfully ask that the committee pass the bill.
Thank you very much. And we have testimony and support from the Retail Merchants of Hawaii and from Derek Carlin. Is there anyone else here wishing to testify on Senate Bill 222? If not, questions, Vice Chair? Nope, we'll move on. Thank you very much. Next measure, Senate Bill 671 relating to health. Excludes from the definition of drug paraphernalia testing products utilized in determining whether a controlled substance contains chemicals, toxic substances, or hazardous compounds in quantities that can cause physical harm or death, including but not limited to fentanyl test strips, and it defines fentanyl test strip. First up, we have testimony in support with comments from the Hawaii State Department of Health.
Good afternoon, Chair Tarnas, Vice Chair Takayama. I'm Robin Loudermilk with the Department of Health. The department supports the intent of the bill and stands by our written testimony. Thank you very much.
Thank you. We have testimony and support from the Hawaii Health and Harm Reduction Center, Nikos Leverins.
Aloha, Chair Tarnas, Vice Chair Takayama, and members of the committee. Nikos Leverins with Hawaii Health and Harm Reduction Center. We strongly support this bill. When I first started working for H3RC, I applied for a grant from the Comer Family Foundation to start carrying fentanyl, to procure fentanyl test strips to improve our syringe exchange program, which has successfully curbed HIV amongst injection drug users for over 3 decades. We like this bill as is, and we're a bit troubled by the Department of Health's testimony. We have xylazine on the horizon. We don't see it in our illicit drug supply right now, but it causes substantial skin injury. Test strips may be in the works. We also believe that a broad range of drug checking tools can improve drug user and public health, including reagents, including spectrometers. And we also are of the view that our state's drug paraphernalia statute should be repealed in its entirety, as it really doesn't serve public safety or public health, but it does serve as a gateway to extensive criminal legal system involvement for people who use drugs, problematic drug users and non. Mahalo for the opportunity to provide testimony. Thank you.
Thank you very much. And next we have testimony and support from several individuals: Samuel Mitchell, Mark Gordon, Will Karen, Ilima DaCosta, Russell Abordo, Natalia Workoff, Aaron Furuichi, Lavada Beard Holdener, Carolyn A., Samantha Toyuka, Thaddeus Pham, Kavika Puahi, and Shannon Rudolph. Is there anyone else here wishing to testify on Senate Bill 671? If not, questions, Vice Chair? Nope. Thank you very much to all the testifiers. We'll move on. to the next measure. Relating to fireworks, establishes the Illegal Fireworks Task Force within the Department of Law Enforcement to plan, coordinate, and engage in law enforcement operations to interdict illegal fireworks, develop a comprehensive strategic plan to stop the importation of illegal fireworks and explosives into the state, promote compliance with the fireworks control laws, and ensure the safety and security of airports, harbors, and other facilities and institutions in the state against the discharge of illegal fireworks and explosives. It also requires a report to the legislature and appropriates funds. On this measure, we have testimony and support from the Department of Law Enforcement, testimony and support from the Department of Transportation, testimony and support from Samuel Mitchell with the Makiki Neighborhood Board, testimony and support from the Pearl City Neighborhood Board, testimony with comments from the Hawaii Harbor Users Group and Matson Navigation and Young Brothers, testimony and support from Hawaiian Humane Society, testimony in opposition from Ka'ili Swan. Please proceed.
Hello, good afternoon, Chair, Vice Chair, and committee members. I oppose this Senate Bill 821 because the majority of people who use fireworks do it safely. Fireworks are not the problem. It is the people who use them. There always be people who do not think of safety first. There are less than a dozen injured people who get hurt from fireworks every year, thousands of people who do it safely. You should not punish those who shoot off fireworks safely. And I strongly oppose this Senate Bill 821. If you have any questions, please let me know. Thank you very much for listening to my testimony.
Thank you very much for your testimony. Next, we have testimony and support from Cards Pintor, Lynn Matasau, Mark Gordon, Kirk Southcott, Daniel Smith, Sarah Armstrong, Peter Donaldson, Beverly Heiser, Jonathan Tetsutani, B.A. McClintock. Oh, excuse me. Jonathan Tetsutani is opposing the measure. I misspoke. Testimony and support from B.A. McClintock, Carolyn Azelski, Jennifer Chiwa, and testimony in opposition from Ryan Willis and Kanoe Willis. Is there anyone else here wishing to testify in Senate Bill 821? If not, questions, members. Vice Chair Takayama, please proceed.
Chair, not so much a question, just a comment that among the group of testifiers, I counted 6 residents of Pearl City whom I know and who do find fireworks to be a troubling part of our society. So they all ask for our support of this bill. Thank you.
Thank you very much. Any other questions or comments, members? If not, let's move on to the next. Thank you to the testifiers. Final measure on our agenda today, Senate Bill 682, relating to animal fur products. This prohibits the sale, offer for sale, display for sale, trade, or distribution of certain animal fur products in the state. First up, we have testimony and support from the Humane Society of the United States. Welcome. The floor is yours. Please proceed.
Final measure of the day. Good afternoon, Chair, Vice Chair, and committee members. Susan Rhee here, Hawaii State Director for the Humane Society of the United States. On behalf of my organization and our Hawaii supporters, I'm here to ask you to please vote in favor of SB 682. Each year, more than 100 million animals are killed solely to be turned into fur coats, keychains, trim on clothing. The majority of these animals, like foxes, mink, and chinchillas, are held captive by thousands of fur factory farms, where they suffer extreme neglect. The methods for killing these animals are just as gruesome, including electrocution and gassing. The fur industry also causes major environmental pollution. The runoff from animals on these fur factory farms pollute airways, waterways, and soil. Many of these chemicals are known carcinogens and are harmful to their surrounding communities. Hawaii has a chance to take an affirmative stand against the cruel practices and environmental harm inherent in the fur industry. This statewide legislation to end the sale of new fur products is essential for Hawaii, for us to do our part to help end animal suffering at the hands of the fur industry. For all these reasons, I respectfully ask that the members of this committee support the passage of SB 682. Mahalo.
Thank you very much. Next, we have testimony in opposition from Chalice Hobbs, Fur Commission USA. Welcome. The floor is yours. Please proceed.
Thank you, Chair and Vice Chair and committee members. Chalice Hobbs, I'm the Executive Director of the Fur Commission USA. I grew up on a 4th generation fur farm. We also had crops, so we raised food and cattle. After that, I worked at the largest global auction house of fur in Finland for 4 years, so I have a really good perspective on the fur industry. I'm obviously opposed to this bill, and these are the reasons why. So the claims in the bill about the fur farming practices and the welfare are not accurate. So the bill overlooks the rigorous standards and certification program that we have in place. This program has been developed with veterinarians, scientists, and welfare experts. Over 96% of the mink produced come from certified farms. So the certification program holds these industries to these standards, and they go over nutrition, housing, biosecurity, veterinarian care. These animal welfare standards and certification is peer-reviewed by PACO, so it's the same organization that does it for the swine industry, the dairy industry, beef industry, poultry, and then our farms are third-party inspected for compliance. So in this bill, it says that we use inhumane, or basically harvest methods of suffocation, electrocution, gas, and poison. This is inaccurate. So all mink farms in the U.S. are harvested in accordance with recommendations of the American Veterinary Medical Association, which is using pure, cooled, and filtered carbon monoxide. No animals here we don't use electrocution, we don't use poison or suffocation, as this is saying. In summary, I would just add that mink farms and the people that are running them are good stewards. No part of the mink is wasted. After the fur is harvested and sold on market, the rest of the remains are used for organic compost, artisanal pet foods, medical research, and I know I'm out of time, but so yeah, I am available for questions though.
Thank you very much. Next, we have testimony in opposition from the American Fur Council and testimony in opposition from Fur Takers of America. Jason Wisniewski, please proceed.
Chair Tarnas, Vice Chair Takayama, members of the Committee on Judiciary and Hawaiian Affairs. My name is Jason Wisniewski, and I am representing the Fur Takers of America, a national organization representing more than 2,900 trappers from across the United States and Canada, including 6 members from Hawaii. I'm testifying to express our opposition to Senate Bill 682, which seeks to prohibit the trade of fur products in the state. This bill is founded on misrepresentations, oversimplifications, and complete omissions of other significant arguments that would allow the representatives considering this bill to make an informed decision whether this bill is beneficial to the people of Hawaii. Fur is a sustainable, natural, renewable resource that has provided clothing to man since the dawn of creation. Fur is a secondary product of the necessary wildlife management tool of regulated trapping, which is supported by the Wildlife Society and the Association of Fish and Wildlife Agencies. Regulated trapping is the only effective approach for wildlife management agencies across the nation to manage and control populations of animals that wouldn't otherwise be managed. Failure to properly manage fur bearers leads to increased human-wildlife conflict, increased prevalence of zoonotic diseases such as parvo, rabies, distemper, and increased threats to human health. Furthermore, trapping is a participant-funded service with the trappers paying for licenses to the wildlife agencies, thus reducing the needs for state and federal agencies to utilize tax revenues to complete these tasks. The equipment, license, training, experience, and fuel to effectively trap and control wildlife is costly, and the marketing of fur is the primary incentive for trappers to provide this service at no cost to the American public. Enacting this bill will further limit the demand and marketability of fur across the country. Because trapping nuisance fur bearers will be necessary regardless of whether fur products are legal, decreasing demand for fur will only ensure that these animals are disposed of in landfills by government agents rather than using these animals for the resources they provide. Section 1 of this bill is laden with misinformation and ignorance of the subject. Specifically, the section fails to acknowledge that fur farming and fur trapping are heavily regulated. The statement also accuses the fur industry of being harmful to the environment without documenting the support that fails to provide the environmental ramifications of alternatives such as faux fur.
If you could summarize, sir, I'd appreciate it. Thank you.
All right. Thank you. I ask you to oppose this bill as it's not good for the environment, and it does have legal ramifications ramifications to fur bear management across the country. Thank you.
Thank you very much. I apologize having to interrupt. I just want to keep moving here. We've got some other testifiers. Thank you, sir. We have testimony in opposition from Anamoda, Inc., Kim Salvo. Please proceed.
Yes, hello, Chair Tarnas, Vice Chair Takamaka, and committee members. Thank you for allowing me to testify this evening in opposition of SB 682. My name is Kim Salvo. I manage one of the premier wholesale fur companies, Anamoda, here in New York City's Fur District. I hope to enlighten everyone about my 32-year profession as a furrier, a job that I love. I love what we sell, the relationships that we have with our clients, which span generations of family-owned retail stores across the country. Now, whereby I do not have an account in the state of Hawaii, I must explain to you how fur ban bills like SB 682 are so misconstrued, ignorant, biased, and misinformed. I submitted written testimony, and I sincerely hope that it is read. But I'm concerned over the clear lack of research in this bill and the graphic language used to dramatize any justification. And so I researched to see if the state of Hawaii had a ban to obliterate cooking a Koloa pig. And I couldn't find anything. That's not up on the docket. And yet that animal and our animal husbandry in the fur industry really isn't any different. Now, what's ironic is how animal activists are so quick to offer up synthetic polyfiber fabrications, make-believe fashions trying to imitate natural fur. Now imagine if they offered you up to cook tofu baked in the ground. I don't think that that would fly, and these imposter substitutes that they are pushing do not cut it. Meanwhile, these animal rights groups are offering the exact opposite of Hawaii's commitment and responsibility in banning plastic food service items, and currently I know that you're looking to ban single-use plastic bottles. And so our industries are really not that far off. I'll close by telling you how I never imagined having to defend my profession. It's become a full-time job as fur bans keep popping up. And the retail stores, the fashion designers, and even legislators like yourself are terrorized by nonprofit groups who are claiming to care for animals. And yet the carve-outs in this particular bill have exclusions to pick and choose the animals who they want to care about. And so that makes SB 682 fall apart at the seams, just as the synthetic fashions that they want people to wear. And so I urge you to oppose 682. Please stop it and allow legal fur products to be sold in the Aloha State. Thank you for your time, and if you have any questions, I will be more than happy to share my knowledge.
Thank you very much. Appreciate your testimony. Next, we have testimony in opposition from the Retail Merchants of Hawaii. Tina Yamaki.
Aloha, I'm Tina Yamaki with the Retail Merchants of Hawaii, and yes, we are in opposition. We don't feel this measure is necessary, as a lot of our stores in Hawaii are already phasing out fur items and trying to liquidate their current inventory. We recognize that there are many top designers who are already ceasing to use fur designs and going more towards synthetics. And also, too, as the other testifiers in opposition pointed out, you know, these farms are heavily regulated and the animals are humanely raised on farms. It's very sad that those who are pushing it are bullies. I've been a victim of being bullied like 3 years ago when they tried to have me fired when I opposed this bill, and I didn't appreciate that. But let me tell you, I'm Tira from Wahiawa, and I'm going to continue to go and support my members on this. You know, with Hawaii and the temperatures in the 80s, there's not a large demand for fur in Hawaii, and it's normally visitors who buy these products. We haven't seen a lot of visitors coming in from Asia, and that's the ones who are buying these products right now. You know, this measure is going to put a hardship on retailers, especially just those local companies who are not able to send it back to their sister stores or be in compliance if the deadline is too early. We do not feel that this bill is necessary. Our industry is already addressing this measure, and thank you for this opportunity to testify.
Thank you very much. And members, we have other testimony. I counted 35 testimonies from individuals and organizations in support, and an additional 5 testimonies in opposition. Is there anyone else here wishing to testify on Senate Bill 682? If not, questions, members? Any questions? Vice Chair Takayama, please proceed.
A question for Mr. Hobbs, if you don't mind. Mr. Hobbs, thank you for being here.
Yeah.
If this bill were to pass into law, what would be the effect on the fur industry?
So our main concern is how this labels the fur farmers. So in the past 3 months, we've had 5 attacks on farms where they came and destroyed property, threatened families, and it's millions of dollars of damage. So,
but in terms of, I'm sorry to interrupt, but in terms of the retail actual selling of fur products, do you see a big impact, minimal impact, or any impact at all?
It's precedent.
Okay.
Yeah, that's the issue.
So since we don't have any fur farms here in Hawaii, if we were to take out the language in Section 1 that refers to farm practices and other such language, would you still object to the bill itself?
Yes, in practice, because one, it sets a bad precedent labeling our product still as not worthy, I guess, for Hawaii. So that'd be the main reason we'd be opposed to it.
Okay.
But then there would be no justification for the bill.
Is there any other, would we have been the first state to enact such a law?
California is the first state and only.
Okay.
That we've defeated, every year we defeat probably 8 bills that are proposed in legislation. On state level, we defeated 2 federal bills. So yeah.
How long has the California law been in effect?
It just started this year.
Okay. All right. Thank you very much. No more questions.
Thank you. Any other questions, members? Representative Ganadin.
What kind of animals are we talking about here? In the testimony from the Humane Society and from others, they're just speaking of fur generally. But I think in your testimony you mentioned mink, like the small rodent.
Yeah. So mink is the largest commercially raised fur product. And so basically in the U.S. that's basically everything. There's very few other farms that raise other types of fur.
So it's one animal, mink?
Yeah, basically. Yeah.
Okay. Just to clarify. Thank you.
Yeah, no problem.
Thank you very much. Any other questions, members? If not, thank you very much to the testifiers on this measure. Thank you all, members, for joining us. And just for those who are here, I know the members are usually listening in from their office, so that's why I always have you come up and speak in the microphone there so they can all hear you and see you on video as well. So, and we have received all your testimony, and I distributed it to the members and to the public yesterday afternoon so that everyone had a chance to read it and review it. So let's move ahead into decision making. First up, we have Senate Bill 1538. I recommend that we amend this measure by adding back in the $495,000 to the Ka'ahumanu Hale to bring it up to a full $5 million that was originally requested by the judiciary. So I'm going to keep the defective date and move it forward to finance for their consideration. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 1538 SD2 with amendments, Chair and Vice Chair vote aye. Representative Ganadin?
Aye.
Representative Holt? Excused. Representative Hashimoto?
Aye.
Representative Ichiyama?
Aye.
Representative Ilagan?
Aye.
Representative Kong?
Aye.
Representative Mizuno?
Aye.
Representative Souza?
Aye.
Chair, your recommendation is adopted.
Thank you very much. Moving on to Senate Bill 151, I recommend that we make some amendments here. I want to adopt the Attorney General's amendments. There's numerous of them adding the word excessive on page 5, line 5, so that it's reports of use of excessive force for law enforcement officers. Page 5, line 11, we need to clarify that officer is referred to as the reporting law enforcement officer. On page 5, line 15 and 19, I want to adopt the recommendation that after receiving written notification, the division head will complete investigation pursuant to subsection C as soon as practicable. Page 6, I want to add a department head or division head is the subject if they are the subject of the use of excessive force report. The reporting law enforcement officer should report to the police commissioner of the respective county If it is a state law enforcement officer, they'll report to the Attorney General, who will be responsible for the investigation. And then we will define excessive force, which means force that is beyond what is reasonably necessary as determined by an objectively reasonable law enforcement officer under the circumstances as actually and reasonably known to the law enforcement officer exercising the force. So those are the Attorney General's amendments. In addition, we want to note on page 6, line 5, 6, and 8, that the State Department Deputy Director should also be notified. We'll also make some changes to the definition of division head for clarity and style. And then throughout the bill, we're going to make sure we clarify the language so that it's clear which law enforcement officer is being referenced when it is ambiguous. So those are the changes that I would recommend. Questions or concerns? Oh, and some technical amendments as well. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 151 SD2 with amendments, noting the excused absence of Representative Holt. Any members voting WR or no? Seeing none, your recommendation is adopted.
Thank you very much. Next we have Senate Bill 372. I'd like to just make some technical amendments and change the effective date to upon approval. Everyone likes it. I think it's a clean bill, good language, and I want to make the effective date upon approval and move it along. It's a single referral. I think it's ready. That's my recommendation. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 372 SD1 with amendments, noting the excused absence of Representative Holt for the remainder of this agenda. Any members voting WR or no? Seeing none, your recommendation is adopted.
Thank you. Next, Senate Bill 210. On this measure, I'd like to make some technical amendments and also it should be specified that the working group is established to, quote, make recommendations for a statewide criminal justice data repository. And then in several places in the measure, we're going to replace the references to program and use the word repository to make it clear. And it has a defective date, which I'm going to keep in there. And then I'm going to put into the committee report that I want to make sure that this criminal justice data sharing working group should also address the concerns, or that should also address the concerns related to public access of information, because I want to recognize that that's an important part of our efforts to provide transparency without violating confidentiality. Those are my recommendations. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 210 SD2 with amendments. Any WRs or noes? Seeing none, your recommendation is adopted.
Thank you. Moving on to Senate Bill 926. My recommendation is to change the effective date to June 30th, 3000 and move this along. I think that it has merit, and I would like to see this move forward. It will have to go to conference, but I think I would like to have us take action in this regard. Is there any questions or concerns, members? If not, oh yes, Representative Souza, please.
Thank you, Chair. I'll be voting no on this measure because I do think it's a slippery slope, and I feel that this could be very dangerous for drivers and open them up to a lot more liability. Thank you.
Thank you very much. Yeah, I think it's going to have to be something that will drivers will have to pay more attention, and I appreciate that is, it's a concern. I understand. Any other questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 926 SD1 with amendments, noting the no vote of Representative Souza and the excused absence of Representative Holt. Any other WRs or noes? Seeing none, your recommendation is adopted.
Thank you. Senate Bill 933, moving on. I recommend that we amend this bill, insert the contents of the bill we had heard before, House Bill 352 HD1, and move it out. I would also like to tell members that I will follow up and check in with the Judiciary Rules of Evidence Committee to see if they have any issues or concerns with this. That's my recommendation. Questions or concerns, members? Representative Ganadin.
It's my understanding that in the Second Circuit, which is Maui County, the advocates are assisting the petitioners in submitting evidence to the court 24 hours in advance of the hearing, which is in compliance with the current law regarding evidence. So outside of changing the rules of evidence, I guess if advocates continue to do that and continue to get certified copies of that evidence directed to the respondent, I don't think that we're going to have an issue with implementation.
Good point. Thank you. Any other questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 933 SD1 with amendments. Any WRs or noes? Chair, your recommendations adopted.
Thank you. On Senate Bill 1079, I'd like to amend it by changing the effective date to June 30th, 3000, and put in the standing committee report that Judiciary is requesting a start date of July 1st, 2025. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 1079 SD1 with amendments. Any WRs or noes? Your recommendation is adopted.
Thank you. Moving on to Senate Bill 1267 relating to protective orders. I'd like to just make some technical amendments and put in the committee report that the Judiciary wishes to have the start date being September 1st, 2023. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 1267 SD1 with amendments. Any WRs or noes? Your recommendation is adopted.
Thank you. Next, Senate Bill 1277, making appropriations for claims against the state, its officers, or its employees. I'd like to recommend House Draft 1 with technical amendments and incorporating the Attorney General's amendments to add the new claims that have come in since the bill was last amended. 9 new claims which were resolved for an additional $4.28 million. And it's in the testimony in attachment B. With those recommendations, I'd like to move it out with an HD1. Questions or concerns, members? Not, Vice Chair for the vote.
Voting on Senate Bill 1277 SD2 with amendments. Any WRs or noes? Your recommendation is adopted.
Thank you. Senate Bill 297 relating to grants and aid. I recommend we amend the effective date to June 30th, 3000, and move it out with an HD1. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 297 SD2 with amendments. Any WRs or noes? Seeing none, your recommendation is adopted.
Thank you. Senate Bill 494 SD2, I recommend that we amend this by changing the effective date to June 30th, 3000, and then put in the standing committee report that the agencies are requesting a delay in the effective date to allow them to promulgate rules. That's my recommendation. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 494 SD2 with amendments. Any WRs or noes? Seeing none, your recommendation is adopted.
Thank you. Next, moving on to Senate Bill 221, making an appropriation to the Department of the Prosecuting Attorney of the City and County of Honolulu. I would like to move this out with an amendment to change the effective date to June 30th, 3000, and put in the standing committee report that the appropriation request is $736,785. That's my recommendation for an HD1. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 221 SD1 with amendments. Any WRs or noes? Your recommendation is adopted.
Thank you very much. Next, Senate Bill 222, making an appropriation to the Department of the Prosecuting Attorney of the City and County of Honolulu. I would like to amend this by changing the effective date to June 30th, 3000, and putting in the standing committee report, the request is for an appropriation of $708,806. That's my recommendation for an HD1. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 222 SD1 with amendments. Any WRs or noes? Seeing none, your recommendation is adopted.
Thank you. Next bill, Senate Bill 671. On this one, I would like to, we had passed out a similar, the same bill, but with a much more succinct definition. And so what I would like to do here is to amend this bill so that it is, follows that approach, so that we would delete what the lines 11 to 15 on page 7 and replace it with the simple phrase, drug paraphernalia does not include fentanyl test strips. And I'd like to, since this is something, a measure that everybody seems to like and we're gonna move it forward, I'd like to change the effective date to effective upon approval. That's my recommendation for an HD1 and send it back to the Senate. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 671 SD1 with amendments. Any WRs or noes? Your recommendation is adopted.
Thank you. Moving on to Senate Bill 821. This measure, we had moved out a number of very good measures out of this committee that would have taken some actions to address the problem of illegal fireworks. We're not trying to stop people from using legal fireworks that they can buy or get a permit to buy. These are to address the importation of illegal fireworks and use of illegal fireworks. And so I'd like to move this measure forward. I checked, because the title says fireworks, I checked to see if we should remove the word explosives, and we don't have to, and I want to explain that the use of the term explosives in this bill is not beyond the scope of the title, because the illegal fireworks that are the primary concern of the public and the legislature are considered explosives under federal law. And Hawaii's fireworks law, found in Chapter 132D HRS, include explosive materials, explosive composition, explosive substance, and explosive component in the definitions of aerial device, display fireworks, fireworks, pyrotechnic composition. So I think that's not a problem. So if you were worried about that, I think we can do that. I would like to amend this, making some technical amendments, so it's an HD1. I would like to delete the Drug Enforcement Agency that's on page 3, line 13, and in its place recommend we include, I recommend that we include the United States Department of Homeland Security, Office of Homeland Security Investigations. So they would be part of this task force. And then I would also, I would like to keep the defective date to move it out and put in the standing committee report that this group should consult with the Hawaii Harbor Users Group in the formation of the plan. With those recommendations, I'd like to move it out as an HD1. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 821 SD1 with amendments. Any WRs or noes? Your recommendation is adopted.
Thank you. And finally, moving on to Senate Bill 682. My recommendation is, considering that we've been educated by the testimony today about how the legitimate fur industry operates and the animals from which the fur is acquired and how they carry out their best practices, I would like to delete the preamble, the section 1 of the measure, so that we're not passing on inaccurate information. And then on page 5, line 15, change the word done to, bless you, change the word done to begun, which is actually the appropriate term used in a savings clause. I'll keep the defective date moving forward into finance. That's my recommendation. Members, questions or concerns? If not, Vice Chair for the vote.
Voting on Senate Bill 682 SD1 with amendments. Any WRs or noes? Seeing none. No vote. A no vote for Representative Kong. Chair, your recommendation is adopted.
Thank you very much. There being no further business before this committee today, we are adjourned.